Yes, my lord.
Yes, appearance of counsel, please.
Profile respect to my noble lord, sir. ND Paul is my name, sir. My lord, announce appearance for the claimant.
How about defendant counsel?
My lord, we've sent the code to respective councils, but
yes, I think they are trying to connect. I can see one Yusuf there. Yusuf Mohammed, yes, I can see him trying to connect. Is there a way, Kabiru, is there a way of you reaching counsel if we have to stand down again? He's trying to connect, I can see. Okay, yes, defendant counsel.
My lord, maybe let me try the mobile line. Let's see.
He's trying to connect. Defendant counsel, can you announce your appearance, please?
Yes, my lord. Respectfully, your lordship, Yusuf Muhammad.
All right, thank you.
For the defendant.
So the matter is for judgment, and I shall proceed to deliver same.
As court pleases.
This suit was originally commenced by way of an originating summons filed on 25th of February 2022. Following a court order dated 30th November 2022, the claimant converted the originating summons to a complaint. The said complaint was filed on 18 January 2023. The claimant was employed by first defendant on 14th August 2015, as stated in the offer of appointment letter. He was initially placed on a 6-month probationary period and was confirmed via the confirmation letter dated September 17, 2018. He was promoted and his appointment was expanded to cover Sokoto, Kebbi, and Zamfara states, as stated in a letter dated 2nd May 2020. The claimant received the MD's award and recognition 2017 certificate on December 7, 2018. He was rated A+ excellent in 2020 annual performance appraiser. He also received a letter of commendation dated August 5, 2021 for his outstanding performance and selfless dedication to duty. The letter dated December 17, 2021 was served on the claimant demanding an explanation for alleged misconduct. The letter was, however, not accompanied by the petition allegedly issued against him. He responded to the letter but was suspended without pay on January 4, 2022. A disciplinary committee was set up comprising the 2nd to 7th defendants. The claimant was invited to appear before the committee on 11th and 13th of January 2022, but he cited insecurity, lack of funds, and short notice as reasons for inability to honor the invitation. Via the letter dated 12 January 2022, the claimant was dismissed for alleged financial fraudulent practices and misconduct. It is a case of the claimant that his right to fair hearing was breached as he was not given a copy of the petition against him. He was not afforded adequate time and facility to defend himself, and the names of the alleged petitioners remained undisclosed. In addition, the claimant also alleges that the disciplinary committee's proceedings were conducted in his absence. Furthermore, he alleges that there was a conflict of interest as the 3rd and 5th defendants were involved in the investigation, suspension, and disciplinary process. It is predicated upon these facts that the claimant is claiming for the following reliefs. A declaration that defendants are under a legal obligation to strictly comply with the provisions of Section 36, sub 1 and 6 of Constitution Federal Republic of Nigeria 1999, as amended, in the determination of the rights, obligation, and liability of the claimant in the circumstances of this case, particularly by affording the claimant adequate time and facility to prepare his defense for purposes of appearing and making representation before the Management Disciplinary Committee of the first defendant comprising of the 2nd to 6th defendants. B, a declaration that by reason of the facts and circumstances of this case, as presently constituted, the defendants breached the claimant's fundamental right to fair hearing as protected and guaranteed under the express and unambiguous provisions of Section 36, sub 1 and 6 of Constitution Federal Republic of Nigeria as amended. C, a declaration that the dismissal of the claimant in the circumstances of the case at hand is clearly against the spirit and intent of the express and unambiguous provisions of the Constitution, and thus unlawful, invalid, and of no legal effect whatsoever. D, an order of court setting aside and or nullifying the purported dismissal of claimant by the defendant in the circumstances of this case. E, order of court directing defendants jointly and severally to pay the claimant the sum of 50 million naira only as general and exemplary damages for wrongful dismissal of the claimant and cost of action. And finally, F, and for further or other consequential orders that this court may consider necessary to give full effect to the rights of the claimant in the circumstances of this case, as protected and guaranteed under Section 36, 1 and 6 of the Constitution as amended. Trial commenced on 18th day of October 2023 with the claimant testifying as CW1. Claimant adopted his witness statement on note filed 18 January 2023 and tendered 15 documents admitted and marked as Exhibit C1 to 15. Under cross-examination, the claimant confirmed that at the time of receipt of awards, the second and third defendants were in service of the first defendant, and it was the eighth defendant that signed the MD's award, which was issued to him. The claimant also stated that it was the eighth defendant that signed the letter revoking his suspension and approved his reinstatement. He insisted that he received the letter of invitation on 8th January. However, when asked to read out content of Exhibit C13, it was elicited that the invitation was sent via WhatsApp on 7 January 2022. It was also admitted that the defendant afforded the claimant with a second opportunity to defend himself. Claimant, however, stated that the period afforded was short. Claimant closed his case on 27 November 2023. After two adjournments, both at the instance of defendants, the defendants informed the court on 5th day of June 2024 that they were unable to secure the presence of their witness. Hence, despite filing a statement of defense, the defendants failed to enter defense. Consequently, the court proceeded to close trial and adjourn for adoption of final written addresses. The final written addresses were adopted on 21st day of February 2025, where the claimant's counsel adopted final written address filed on 24th June 2024 and reply on points of law filed 11th September 2024. Defendant's counsel adopted final address filed on 7th August 2024. In the submission of the claimant in the final address, two issues have been raised. One, whether having regards to the clear and unambiguous provisions of Section 36, 1 and 6 of the Constitution, Federal Republic of Nigeria as amended, the defendants did not breach the claimant's right to fair hearing in the determination of his guilt and subsequent dismissal from the service of the first defendant. Two, whether having regards to the facts and circumstances of the instant case, the defendants, having failed to lead evidence in support of their pleadings, have conceded to the claims of the claimant. On the first issue, it was submitted that the claimant's right to fair hearing was breached when he was denied access to the petition and witness statements, that the defendants failed to provide the claimant with these crucial documents, which were necessary for his defense, and that this denial of access to vital information breached the claimant's right to fair hearing as he was unable to adequately prepare his defense. Counsel cited Ebele Okoye versus Commissioner of Police. Citation is provided. He submitted that the disciplinary committee that heard the claimant's case was not independent or impartial, as some members of the committee had prior involvement in the investigation and had already made findings against the claimant, citing General Electric Company versus Akonde. Citation equally provided. This lack of independence, according to claimant's counsel, further breached the claimant's right to fair hearing, as the committee's bias and preconceptions likely influenced their decision. It was submitted that the claimant's right to fair hearing was also breached by the defendant's failure to provide him with adequate time and facilities to prepare his defense. Claimant was given insufficient notice of this disciplinary committee hearing and was not provided with the necessary resources to prepare his case. Counsel placed reliance on UDO versus Civil Service Commission, Akwa Ibom State, and others. In addition, the defendants have predetermined the claimant's guilt before the disciplinary committee hearing. The letter dismissing the claimant on January 12, 2022, Exhibit C14, clearly indicates that the defendants had already made up their minds about the claimant's guilt. This predetermination of guilt breached the claimant's right to fair hearing as he was not given a genuine opportunity to defend himself. Claimant's counsel equally argued that the disciplinary committee was want of independence and partial, and that the guilt of the claimant was predetermined as the committee failed to hear from his side, thereby going against the principle of audi alterem partem and nemo judex in causa sua. Counsel submitted that the outcome of a proceeding that breaches an individual's right to fair hearing is an affront to the provision of Section 36(1) and 6 of the Constitution, Federal Republic of Nigeria. Therefore, null and void. Claimant's counsel thus stated that the claimant's dismissal from service must be set aside and the matter remitted for a fresh and fair hearing, citing Adebesin versus State. On the second issue, counsel submitted that defendants' failure to call evidence in support of their defense amounts to conceding the suit, as their statement of defense is deemed abandoned and of no legal effect, citing military governor of Lagos State and others versus Adeyiga and others, amongst other cases cited, that by not adducing evidence, the defendants have rested their case on the claimant's unchallenged evidence, relying on New Breed Organization Limited versus Eromosele. It was also submitted that the defendant's failure to adduce evidence amounts to withholding of evidence, which raises a presumption that the evidence will be unfavorable to them. He cited in support Ekwezo and others versus the registered trustees of Saviour's Apostolic Church of Nigeria and equally Section 169D Evidence Act 2011. In conclusion, claimant's counsel submitted that this suit is unchallenged and the court is bound to accept the unchallenged version as conclusive. He therefore urged court to resolve issues formulated in favor of the claimant. Defendant's submission. Learned counsel to defendant raised a sole issue for determination, to wit, whether upon all facts from the evidence presented before this court, the claimant has proved his case on the balance of probability to warrant judgment of this honorable court in his favor. Learned counsel to defendants argued that they did not breach the claimant's right to fair hearing, as they provided him with adequate opportunities to defend himself in line with Section 36(1) and 6 of the Constitution, that the claimant was given adequate notice of the allegations against him and was provided with opportunities to respond and defend himself. However, the claimant failed to utilize the opportunities provided to him to defend himself and therefore cannot complain of a breach of fair hearing. Counsel made reference to Exhibit C10, 11, 12, and 13, and cited case of Dairo versus Stanbic IBTC Bank and another, and equally MFA and others versus Inonga. To the defendant, the further submission of defendant's counsel that the claimant has the burden of proof to show that he's entitled to the declaratory relief sought and must succeed on the strength of his own case, not on the weakness of defendant's case, as declaratory reliefs are not granted as a matter of course, but only when credible evidence has been led by the claimant. He cited Satomi versus and others versus PDP Borno State and another, amongst others. Claimant filed a reply to defendant's final written address, and counsel maintained in that reply that the defendants failed to address crucial issues relating to fair hearing, specifically with regard to A, denial of fair hearing, as the claimant was not served with the alleged offense alongside Exhibit C10, thereby violating his right to fair hearing. Counsel cited Udo versus Civil Service Commission, Akwa Ibom State, and others. B, bias and lack of independence of the committee that determined the claimant's guilt, as some members were involved in the investigation and signing of suspension letter. Counsel made reference to Section 36, sub 1 of the Constitution, Federal Republic of Nigeria. It was also submitted that the defendants failed to respond to issues and arguments raised in paragraph 5.0 of claimant's final address and thus failed to discharge their burden of proof and deemed to have conceded. Claimant's counsel cited in support Ugwaja versus Akitoye, Showemimi, and others. He further submitted that the claimant has led credible and cogent evidence to be entitled to relief sought, and that the burden of proof shifted to the defendants. He cited Okoye and others versus Nwako, and equally Section 131 and 133 Evidence Act, that instead of defendant to challenge the case of the claimant with credible evidence, defendants filed address built on speculation and sentiments rather than cogent and credible arguments. Counsel placing reliance on Eziogu versus Ohayere and equally Rene versus Odibo and another submitted that courts are not permitted to act on speculation. Now the decision of the court. Having carefully considered the relevant processes filed in this suit, evidence adduced, and final written submissions of learned counsel to both sides, I find that the germane issue central to the just determination of this suit is whether the claimant's right to fair hearing was breached by the defendants. Before examining the substance of this suit, it is noteworthy that the defendants failed to call evidence despite filing a defense. The claimant argues that this failure constitutes a concession on the part of the defendants. It is, however, noteworthy that despite failing to call evidence, the defendants partook in the proceedings by cross-examining the claimant. Hence, this suit is not unchallenged. More so, the burden of proof remains on the claimant to establish his case through credible evidence. The defendant's failure to testify or present evidence does not alleviate this burden. As the court held in Atunwa versus Ladenika, 1998, 7 Nigerian Weekly Law Reports, Part 557-221 and 228-229, the claimant must prove his own case on its own merit, regardless of the defendant's actions or inactions. See also Mishore versus Aregbesola, sections 131 to 133 Evidence Act 2011, to the effect that the burden of proof lies on he who asserts. Regarding the substantive matter, the crux of the claimant's case is that he was an employee of the first defendant and that he was dismissed from the employment of the first defendant without ample opportunity to be heard, thereby trampling on his constitutionally enshrined right to fair hearing. The claim of the claimant is hinged on provisions of Section 36, sub 1 and 6 of the Constitution, Federal Republic of Nigeria, as amended. And the same has been reproduced here. I wouldn't need to read that out. Seeing that the claim of the claimant is fundamentally hinged on fair hearing, I am tasked with determining whether the claimant was afforded fair hearing. The doctrine of fair hearing is a fundamental principle that applies to both judicial and non-judicial bodies, including administrative tribunals. This doctrine requires that individuals be given fair opportunity to be heard before a decision is made that affects their rights, obligations, or interests. See, amongst others, Iderima versus Rivers State Civil Service Commission. The citations for the other cases are included in the body of this judgment. Administrative bodies such as a disciplinary committee are not expected to follow the same strict procedures as courts of law when conducting proceedings. However, they are still required to act in good faith and provide fair hearing to all parties involved. See NCATC, the case of NCATC citation is 1991, 5 Nigerian Weekly Law Report, Part 192 and 388. From the claimant's statement of facts and depositions in witness statement on oath, I have deduced that the claimant was issued a letter titled, I quote, Audit Demand for Explanation, unquote, on 17 December 2021 by the first defendant, demanding explanation as to why the management of the defendant should not consider the alleged acts of the claimant spelled out in the letter as fraudulent. See Exhibit C10. In reaction to this letter, the claimant on 20 December 2021 issued a letter denying allegations spelled out in the first defendant's letter of demand for explanation, Exhibit C11. The first defendant, apparently unsatisfied with the representation of the claimant, proceeded to suspend the claimant via the letter dated 4 January 2022, Exhibit C12. From evidence elicited from the claimant by defendant's counsel, the claimant was invited to face disciplinary panel via the WhatsApp message dated 7 January 2022. See page 33 of record of proceeding. He was also invited via WhatsApp message dated 12 January 2022, Exhibit C13. Relevant excerpt of Exhibit C13 is reproduced below, and I quote, "The management of Kaduna Electric wishes to officially invite you to appear before Management Disciplinary Committee to enable you more opportunity to defend yourself, scheduled as follows: Tuesday, 11 January 2022, time 9 a.m. Venue, Corporate Headquarters Training Room. Please note that refusal to attend to this disciplinary invitation is as good as one having accepted these charges or offenses by management." In response to this message, claimant on 10th day of January 2022 wrote this, I quote, "Sir, I have received an invitation to face disciplinary committee in Kaduna, but to the deplorable state of the road, it's no longer safe to use, and coupled with the lack of funds to accommodate myself there at Kaduna. I have consulted with my family and relatives. They all warned me on the dangers of embarking on such a journey from Kebbi to Kaduna. Despite the security challenges, I may be particularly targeted by those affected one way or another by those affected by the nature of my assignment in this company. Based on the numerous life-threatening phone calls and text messages I have received on a daily basis since the becoming public of my suspension, I'm always ready to defend my innocence against all the allegations against me, if and only if an alternative to traveling to Kaduna is made possible. I will be grateful if that alternative is provided. Thank you," unquote. The first Defendants Management Disciplinary Committee once again extended an opportunity to the claimant by a WhatsApp message dated 12 January 2022, wherein the claimant was given the opportunity to appear before the committee on 13 January 2022. On same day, the claimant replied the message stating that he would not honor the invitation. Some excerpt of the message is reproduced below. I quote, "Sir, I have received an invitation to face a disciplinary committee at the headquarters in Kaduna. Honestly speaking, I will not honor that invitation because of the insecurity. The roads are not safe to travel along. My life could be endangered considering the number of enemies I have. Therefore, I can't risk my life to travel to Kaduna considering the insecurity situation faced in the northern Nigeria," unquote. Having carefully considered the evidence before me, particularly Exhibit C13, it is clear that the claimant raised concerns about funding, accommodation, and security as reasons for not appearing before the disciplinary committee. It is my view that whilst lack of fund and accommodation may not be satisfactory reasons, the claimant's refusal to attend to security concerns is a significant factor in this suit. The question that arises is whether the reason is satisfactory. I am of the view that while security concerns may be a legitimate reason for not appearing, they must be supported with verifiable evidence. In this case, the claimant failed to provide the first Defendants Disciplinary Committee with evidence such as copies of alleged life-threatening messages, which undermines the credibility of his concerns. To establish a satisfactory reason for not appearing, circumstances must be genuine, verifiable, and unavoidable. Examples of such circumstances include A, serious illness, a severe medical condition that prevents attendance corroborated by medical reports. B, death in the family, a recent bereavement that requires immediate attention. C, transportation disruptions, flight cancellations, road closure, or other unforeseen disruptions that prevent attendance, etc. It has now become necessary to determine whether the disciplinary committee is precluded from proceeding with disciplinary proceedings, given the claimant's assertion that security concerns prevent him from appearing. In this case, it is my firm view that the claimant's failure to verify his security concerns means that the defendant's decision to proceed with the disciplinary proceedings was justified, and I so hold. I have observed that the claimant asserted in paragraph 13 of his witness statement on oath that the alleged petition written against him did not accompany the query. To solve this issue, the content of Exhibit C10 is reproduced thus. It's titled Audit Demand for Explanation. Following a petition received by the audit team through the Executive Management Committee and the subsequent visitation to the team to Kebbi South and Sokoto South AOs on 13th October 2021, the team conducted a field exercise within your area of coverage and subsequently interviewed some randomly selected staff across the 3 franchise states of the company Kebbi, Sokoto, and Zamfara State. It was observed by the team that you have continuously over the time used the privileges conferred on you by the virtue of your department and unit to mandate most of the CSMs and SRs from those states to be diverting the lost revenue of the company to various bank accounts belonging to non-staff of the company provided by you for your personal gains. Otherwise, you threaten them by sending a report to the MD directly that may affect the job security. To this end, you are therefore required to explain within 24 hours from the time you receive this memo as to why management should not consider your act as fraudulent and sabotage on the company's efforts to improve its collection and reduce the level of its commercial and collection losses, unquote. I must state that I do not agree with the position of the claimant, seemingly insinuating that failure to attach the alleged petition amounts to denial of fair hearing. Exhibit C10 clearly outlines the allegations against the claimant to which he was required to address and provide explanations to exculpate himself. As previously noted, he responded to the query and the defendant, finding his response unsatisfactory, proceeded to suspend him, invite him to face disciplinary committee, and subsequently dismissed his employment. This stance is further supported by the fact that the reasons cited in the query are also mentioned in the claimant's dismissal letter, Exhibit C14, indicating a clear connection between the allegations, the response, and the subsequent disciplinary actions taken. I so hold.
As the court please.
Fair hearing in administrative balance simply requires that an employee alleged to have committed an offense is given adequate notice of the allegations leveled against him and afforded the opportunity to make representation in his defense. See the classic case of Baba versus NCATC and another Supra, ATA Poly versus Marina, Onongwawan Mary Ntewo versus University of Calabar Teaching Hospital and another. Citations are all provided. Where it was held, particularly in the case of Ntewo, University of Calabar, the administrative panels are set up with the primary purpose of fact-finding in respect of matters that may require investigations as part of a disciplinary procedure. Hence, all that is required is that they be guided by the principle of natural justice, in the sense that all people involved be notified of any allegations against them and be afforded adequate opportunity to answer them. I've also observed that the claimant alleges that there was a conflict of interest as the third and fifth defendants were involved in the investigation, suspension, and disciplinary process. However, the claimant failed to adduce any evidence in support of this claim. It is right that facts not supported by pleadings are deemed abandoned. See Akimbade versus Babatunde, 2018, 7 Nigerian Weekly Law Reports, part 1618, 366 at page 393, paragraphs F to G. Okeke versus Okeke, 2019, 17 Nigerian Weekly Law Reports, part 1701, 267. The mere fact that the parties were involved in the investigation, suspension, and disciplinary process against the claimant is not conclusive proof of conflicting interest or partiality, and I so hold. From all that have been said above, it is the finding of this court that the claimant was afforded a fair hearing. Consequently, this suit lacks merit and is determined as follows. Relief A succeeds, relief B to F fail, and the suit is hereby dismissed. Judgment is entered accordingly.
As the court please. We are grateful, sir.
You're welcome.
Thank you, ma'am.
That should be all for Sokoto. So, and you may respectively exit the site. Thank you.
As the court please.
Thank you.
All right.
They no present their case.